All right, Mr. Malou, you're invited to proceed.
Thank you, Mr. President.
I'm sorry, before you start.
Oh,
Can we please
sorry.
have the,
We'll just need a moment.
screens changed? Could we please have the HDMI? Could we please get this on the screen?
Perfect.
No, I'll just use this.
Okay. Thank you, Mr. President, and I hope you all enjoyed the lunch as much as I did. I have to say, I don't know if it's a function of being in Paris or this particular hotel, probably a bit of both, but I'm not used to having those types of lunches during my breaks. But welcome it, so thank you perhaps to Respondents Council for picking the venue. Let me turn to the essential security defense, and before I do, there's one point that I do want to make, which is, that this is a new submission. I do want to make the point, I do take issue with that for one important reason, which is all of this is in the record, right? Our submissions are what you're hearing from Ms. Champion and I, but none of this is new, and I think that's an important point. And as I said at the outset, it is an important theme for us because none of this has changed. These are the arguments. I hope you're not tired. You may be tired of hearing them from us, but they are the same arguments that you will have heard, supplemented by additional evidence. But none of this is new submissions. And likewise with the essential security submission that I will make, these are all arguments that you will have heard before. And I think it's actually a fairly straightforward argument in the first instance when we're talking about the essential security defense that was first raised in the rejoinder. And I take you to Article 22.2, which is the essential security provision. And it says, nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary for the fulfillment of its obligations with respect to the maintenance or restoration of international peace or security or the protection of its own essential security interests. Nothing precludes a party from applying measures that it considers necessary to do that. And the reason why this is important, this language, is the language, the ordinary meaning of it, makes it clear that they must adopt the measures for the purpose of achieving that essential security interest, which means they must know the essential security interest at the time they're applying the measures. That's the language in 22.2. They're not precluded from applying measures that they consider necessary to protect their essential security interest. But you can't apply measures, not know what that essential security interest is, come 6 years later and say, oh, I now have an essential security interest for which I can justify measures that I applied 6 years ago. That's not the way it works. You must know at the time that you are applying the measures what the essential security interest is. And that's exactly what the International Court of Justice said in the Nicaragua versus USA case, where the treaty there was dealing with non-precluded measures clause. The present treaty shall not preclude the application of measures. In that case, if you look at D, necessary to fulfill the obligations of a party for the maintenance, restoration of the international peace and security, or necessary to protect its essential security interests. Whether this is self-judging or not is totally irrelevant, by the way, to the question, this temporal question that or issue that I'm raising, which is at what point in time must the essential security be identified or be known? And the court there said, they specifically said, we have to bear in mind the chronological sequence of events. They must have been, at the time they were taken, measures necessary to protect its essential security interest. And the same is, of course, true. You can end the analysis right there. But if you feel the need to go on, members of the tribunal, there's another important point, which is this is not a jurisdictional clause. And you've heard the change in, in order to introduce this late, they raised it as a jurisdictional defense. And then you started to hear the vocabulary change to justiciability, which is different from jurisdiction. right? So this is not a jurisdictional defense, it's an affirmative defense to, we would say, a remedy. It specifically says that nothing in this agreement shall be construed to preclude a party from applying measures. That's what it is. It says it allows them to apply measures. It does not exempt them from the obligation to comply with the treaty or to pay compensation for a breach of the treaty. They're just entitled to keep their measures in place, assuming it was done in a timely way, etc. And that's exactly what prevent means, the ordinary meaning, to prevent from taking place. And that makes sense in the context of international investment treaty law and international trade law. And this is important because the exception applies equally to the investment chapter as well as the trade chapter. It applies equally to chapter 10 and 21. And it's important to note in that context, why is, when I say it just goes to the remedy, why is that relevant? Why is that important? Because in the trade context, the primary remedy is the removal of a non-conforming measure, right? If someone is, they apply a quantitative restriction or something like that, in the trade context, the primary remedy under international law is you have to remove that quantitative restriction. And they're saying, well, you don't have to remove the measure if it's done to protect your essential security interest. And likewise, in the investment treaty context, 10.26 specifically contemplates the possibility of restitution of property. But here, this provision says you can keep the measure in place if it's to protect your essential security interest, but it does not exclude the possibility of monetary damages, and that's exactly the issue that was before the Eco-Oro versus Colombia Tribunal under the Canada-Colombia bit. And again, this has nothing to do with whether it's self-judging or not. It's a question of what is the remedy? What does this get you? Whether, if it is properly invoked, whether self-judging or not, what does it get you? And the Eco-Oro versus Colombia case dealt exactly with this question when they were interpreting language that was similar. Nothing in this agreement shall be construed to prevent a party from adopting or enforcing measures necessary to do various things. And they said Colombia also provided no justification as to why it is necessary for the protection of the environment, in that case, not to offer compensation to an investor for any loss suffered as a result of the measures taken by Colombia to protect the environment, nor explained how such construction would support the protection of investment in addition to the protection of the environment. And they said, and Canada came in with Colombia there, and they said the tribunal there did not accept Canada's non-disputing party submission that in such circumstances payment of compensation is not required. So very similar to here. They said, it just says you can adopt the measure, not that you're precluded from the compensation obligation. So Eco-Oro is very much on point, we would say. And there, again, it was a situation where you had Canada and Colombia both coming in, making submissions to that effect, and the tribunal said, no, that's not what it says. That's not the ordinary meaning. It doesn't comport with the purpose of this treaty either. And it doesn't comport with the purpose of the treaty in this case either. I've already taken you to the preamble, but it also needs to be interpreted in a way that is consistent with the purpose and object of this treaty, which includes promoting broad-based economic development in order to reduce poverty and generate opportunities for sustainable economic alternatives to drug crop production, to promote new employment opportunities and increase the living standards. That's the kinds of things that this investment was doing. They've relied on travaux, and they put in hundreds of pages of travaux. But if the ordinary meaning is clear and unambiguous, then one needs not go to the travaux. And we would submit, and Colombia has even said, that to Article 22 point B is unambiguous. So there is no need to go to the travaux. But if you do go to the travaux is not very clear. The application was fundamental. There's some talk about subsequent agreement, and I think this is important. In Infinito Gold, what the tribunal there said was that even if you have non-party submissions in the middle of an arbitration, that cannot be used to form a subsequent agreement. Why is that? The tribunal said, even if the tribunal confer an agreement from the contracting state's submissions during the proceedings, quad non, this agreement would post-date the commencement of this arbitration, and the tribunal could not take into a consideration in favor of one litigant to the detriment of the other without incurring the risk of breaching the latter's due process rights. So you can't take into account a subsequent agreement during the course of the proceedings and use it against one of the litigating parties. That's what the Infinito Gold versus Costa Rica award found. And in any event, even if there was a subsequent agreement here between the parties, it cannot be used to modify the treaty obligations. You can't use a subsequent agreement to modify treaty rights, and the Sempra Tribunal says more or less the same thing. I'll briefly touch upon the last couple of arguments with respect to essential security. You have our submission that we think it's late. The Tribunal in Procedural Order Number 9 only allowed the submission insofar as it was, for purposes, it was a jurisdictional objection. I don't think it is a valid jurisdictional objection. We've explained to you why. Arbitrator Periscano asked this a question of counsel for a respondent during the hearing, noting that in the footnote it says the tribunal or panel hearing the matter shall find, suggesting that the tribunal has the authority to make a finding, and we would say that confirms in our submission at least that there is jurisdiction. It's not a jurisdictional question in our view. It's a merits defense. It's an affirmative defense. And as a merits defense, it is out of time. According to Procedural Order Number 1, they were only allowed to raise defenses that were responsive in the reply and the rejoinder submissions. That's in Procedural Order Number 1. And in Article 20, in Rule 26 of the ICSID arbitration rules, it says any step taken after expiration of the applicable time limit shall be disregarded unless there are special circumstances. And there are no special circumstances here in our submission because there can be no new facts, because otherwise it's out of time for different reasons. The fact must have been known at the time the measure was taken in order to come within the protection of the provision. There is also a good faith defense. We don't think this is a defense that's raised in good faith for two reasons. One is it's simply a recasting of arguments they made in the counter memorial and the rejoinder. You can see that at slide 255. It's more or less the same reasons to fight organized crime, but they just they recast that as all of a sudden an essential security interest in the rejoinder. But more than that, as I think is accepted by both parties, one of the questions when you're assessing good faith is whether or not the measure is plausibly connected to the essential security interest that's been identified. And for the reasons Ms. Champion has already mentioned and I've discussed earlier, there is no connection here between the measure and whether you call it a police purpose, a public purpose, or an essential security interest. There is no rational connection between the measure adopted here and that essential security interest. Colombia accepts that the claimant's wrongdoing is not the subject of the measures. And if they were actually concerned with this essential security interest of fighting organized crime, they would have gone after the assets of those individuals whose actions are actually, they say, criminal. And they haven't done that. And lastly, we rely as certainly we don't think you need to get this far down the chain, but the most favored nation treatment standard is one that we think applies if the tribunal were to find that this were to preclude us from bringing our claims, because there are other treaties that don't preclude investors from those states from bringing claims in similar circumstances. And just one example is the Colombia-Swiss bid. I'll turn it over to my colleague, Ms. Kaloun, to deal with the jurisdictional issues.
Good afternoon, Mr. President and members of the Tribunal. Thank you for the opportunity to address you again on behalf of the claimants. I will be providing the Tribunal with a summation of the jurisdictional issues in dispute between the parties. As a threshold matter, since the parties' opening submission at the May hearing, the only movement in jurisdictional objections between the parties has been the addition of overwhelming evidence to the record through the testimony of Mr. Seda and claimant's experts that reaffirms claimant's status as protected investors who have made a protected investment in Colombia and who have standing to adjudicate Colombia's unlawful conduct before this tribunal. Turning first to claimant's status as protected investors under the TPA. It's agreed between the parties that in order for an ICSID tribunal to exercise jurisdiction over a claimant, the ratione personae requirements in both the ICSID Convention and the TPA, extracted on this slide, must be met. It's uncontested between the parties that each of the 7 individual claimants and JTE International Investments qualify as protected investors under the TPA and the ICSID Convention. It is also uncontested that Boston Enterprises Trust is a protected investor under the TPA. The only remaining issue in dispute between the parties is whether Boston Enterprises Trust qualifies as a protected investor under the ICSID Convention. In the TPA, the contracting parties expressly agreed that a trust is a type of enterprise that has legal personality and standing to initiate international arbitration. The ICSID Convention, in turn, extends standing to any juridical entity. This is not a limited class, and it extends to any juridical entity. Moreover, to the extent that there is any ambiguity in the ordinary meaning of this phrase, the travaux préparatoires, Colombia's favored tool of treaty interpretation, confirm that the drafters wanted to keep the definition as neutral as possible in order to take into account differing national law. Colombia, after having agreed to include trusts as a type of enterprise within the TPA, cannot retroactively seek to add conditions of corporate liability when the clear terms of the treaty contemplated incorporation of trust within the concept of an investor who could initiate ICSID arbitration. Accordingly, the Boston Enterprises Trust should be held to be a covered investor with standing to act as a claimant. Turning next to claimant's ownership of a protected investment under the TPA. Article 10.28 of the TPA incorporates a very broad definition of what constitutes an investment, to include every asset that an investor owns or controls, which has the characteristics of an investment. The TPA thereafter sets non-cumulative and non-exhaustive examples of what such characteristics could include. As highlighted in claimant's opening, there are a number of decisions that support adopting a broad interpretation of Article 10.28 of the TPA. Accordingly, it's clear that the claimants own a broad range of investments in Colombia, each of which display the characteristics of an investment. However, the parties disagree on whether the ICSID Convention creates a separate jurisdictional hurdle that investors must discharge in order to gain access to ICSID arbitration. The ICSID Convention does not include a definition for the term investment, or the so-called cumulative criteria that Colombia is attempting to read into the Convention. And a number of tribunals, including those on the slide, have rejected a so-called double keyhole test. However, in any event, and as it has only been reinforced since the hearing, claimants meet each of the criteria advanced by Colombia. First, claimants have made a commitment of capital or other resources as protected investments. Firstly, there is no minimum contribution that needs to be made in order for an investment to qualify as protected, and Colombia itself has conceded on numerous occasions that claimants have made a contribution. However, they disagree as to whether this contribution was allegedly large enough. But it became apparent at the hearing that Colombia had ignored evidence of contributions that were put onto the record by claimants, of contributions in both Luxay and Newport, that can be found in Exhibits C358 and C359. Moreover, as this tribunal has now heard, straight from the source himself, Mr. Seda contributed significant know-how and brand value to create a highly successful portfolio of projects that had great potential within the Colombian tourism market. Second, claimants have assumed significant investment risk through their investments. Claimants assumed the risk that they would lose their invested capital, and concomitantly, they held an expectation of gain or profit. Accordingly, even applying Colombia's test, there is no question that the claimants made an investment in the state. Moving to the next objection. Now, as Mr. Malou and Ms. Champion have already covered extensively, the claims advanced in this arbitration by claimants are directly related to the measures in dispute and are not limited to the Meritage project. As claimants have established in their submissions to date, all that is required at the jurisdictional stage with respect to this objection is a relationship of apparent proximity between the challenged measure and the claimant or its investment. Any further analysis is more suitably reserved for a consideration on the merits of the claim. Now, Mr. Malou and Ms. Champion have gone far beyond establishing a relationship of apparent proximity between the measures and the impact that these measures have had on Luxay, as well as the development projects and Royal Realties.
Just a moment.
Sorry.
I need you to slow down.
Sorry.
It's making it very difficult for the interpretation as well.
My apologies.
Start with that sentence again.
As Mr. Malou and Ms. Champion have already covered extensively in their submissions, the measures at issue in this arbitration severely affected not only the Meritage project, but also Luxay and Royal Realties' pipeline of development projects. The impact on these measures, which was widely publicised, should have been foreseeable to Colombia before it wrongfully initiated asset forfeiture proceedings against the Meritage project. Moving to the final objection, both Boston Enterprises Trust and Brian Haas have standing in this arbitration. First, addressing Boston Enterprises Trust, the settler, trustee, and beneficiary of Boston Enterprises Trust is a US national that has maintained continuous ownership of an investment in Newport since 30 March 2016 and in Luxay since 14 February 2012. The change in ownership structure through affiliated entities of the same nationality was purely to maintain anonymity as established in claimant's opening submissions, as opposed to an effort to gain access to ICSID arbitration. It is not appropriate to draw parallels between this corporate restructuring and a situation where there has been an abusive process, because at all points, Boston Enterprises Trust would have been entitled to have recourse to ICSID arbitration. And tribunals have recognized that internal corporate organizations of this kind are permitted. With respect to Mr. Haas, Colombia contends that Mr. Haas does not have standing in this arbitration because he structured his investment in Luxay through a family trust. However, the record shows that Mr. Haas made his investment through Haystack Holdings, which in turn was controlled by a family trust, which Mr. Haas and his wife are the settlers and sole beneficiaries, as can be seen in C222. As Mr. Haas is the ultimate beneficial owner of the shares, he has standing to claim relief before this tribunal, pursuant to the principle in international law that grants standing and relief to the owner of the beneficial interest. Mr. Malou will now conclude claimant's opening statement.
And I asked Ms. Kaloun to leave me with 3 minutes, and so I apologize. If she was rushing, it was because I had asked her to leave me 3 minutes, which I think I do have. And what we want to end is with our request for relief. You can see on slide 278, and again, this is the same request we've asked from the outset, that the tribunal declare that there have been breaches, that the claimants be awarded $255.8 million plus interest, and we're also claiming moral damages. Now, I want to say one note on moral damages. This is the first case in which I've ever claimed moral damages, so we didn't take the decision lightly to make a claim for moral damages. And I know we've covered a lot of uncomfortable topics over the last several years, including the alleged extortion scheme and corruption issues. And we don't think you need to find any of that in order to find that claimants have prevailed in this case. And for that reason, we thought, is this something, we want to go there because they are uncomfortable topics. But we thought we had to, because this is an important part of what happened in this case, and we had to tell that story to show how egregious the conduct was. Mr. Seda has been subject to, and his investments and the investors in this case have been subject to rather egregious conduct, and we think it is a case where moral damages would be appropriate to show that this is not acceptable. It's important to show that to other investors, and it's important to show that to the treaty parties. And I want to end where Mr. Seda ended in his testimony. And it's up on the screen. And I asked him, why did you go back to Colombia? You went back to Colombia. With all of this happening, why do you go back to Colombia? And he said, and why are you pursuing all of this? There's the threat of potential investigations, and all of this is coming out because you're pursuing this claim. Wouldn't you just want to put this all to an end? And he said, because I'm defending my name, and because this is going to follow me no matter where I go. It's true. It's going to. It has for the last several months. And it's going to continue to follow him. And he wants it to come to an end. And he wants to put an end to this. And putting an end to this is hopefully this tribunal saying that the type of conduct that happened in this case is not acceptable. It's not what Colombia and the US wanted when they signed this treaty. It's not meant, if this type of conduct is not what this treaty is meant to protect, then I don't know what is. It's not what the claimants deserved. It's not what the people of Colombia deserved. But in order to put an end to this, the claimants must be compensated for the wrongful conduct that happened in this case. Those are our submissions.
Thank you very much, Mr. Malou. We will have a short break, of a few minutes.
Just for setup, yes,
Yeah.
if I may. Thank
But
you.
we will stay in the room, or do you need?
We're in your hands. We can leave, come back.
No. I mean, how long does it take you to get
I
prepared?
think to switch computers and do some switching in the team here, so 5 minutes should be fine. 10 if the tribunal wishes to have more. We're in your hands.
Let's say 10 minutes, yeah?
10 minutes?
We get an electronic version.
Yes, it will be sent right away.
So I think everybody's ready to resume, and the floor now goes to Mrs. Bani Fatemi.
Thank you, Mr. President. Ms. Ordóñez will start for Colombia with your permission.
Okay. Yes, please.
I will be addressing you in Spanish as well. Señor presidente y señores coárbitros, antes de darle la palabra a nuestras colegas de GBS Disputes, haré unas breves observaciones en relación con dos grandes temas. En primer lugar, me referiré a las expectativas que explican e informan el consentimiento de Colombia al arbitraje inversionista-Estado. Entre ellas, el carácter excepcional tanto de este mecanismo como de los derechos del inversionista extranjero conforme con la sección 10 del Tratado con los Estados Unidos de América. En segundo lugar, haré referencia a algunos contenidos básicos de la Ley de Extinción de Dominio, los cuales, después de casi 4 años de litigio frente a ustedes, deberían estar claros para todos los aquí presentes. Pero es necesario hacer referencia a estos puntos básicos porque, según lo escuchado en la mañana de hoy, los demandantes sugieren que estos puntos o no han quedado claros o están siendo objeto de tergiversación. Sobre el consentimiento de Colombia al arbitraje inversionista-Estado, me referiré a 3 premisas que consideramos en Colombia como principales. De una parte, entendemos el derecho internacional de la inversión extranjera como un derecho de protecciones mínimas, que no busca poner al inversionista extranjero en una posición más favorable a la que tiene el inversionista nacional. Así entendemos los derechos de los inversionistas extranjeros y de sus inversiones en relación con el estándar mínimo de trato, pero también en relación con los estándares de expropiación, trato nacional y protección y seguridad plenas. Nos parece importante recordar este entendimiento, pues no podemos evitar identificar en la posición de nuestros colegas de la contraparte cuestionamientos que, lejos de estar soportados en un entendimiento estricto del derecho internacional de la inversión extranjera, parecen estar dirigidos a rechazar un cierto tipo de situaciones que, si bien no resultan cómodas, son típicas de la acción de extinción de dominio en Colombia y son soportadas por igual por todos los inversionistas nacionales y extranjeros que invierten en nuestro país en propiedades de origen ilícito. De otra parte, entendemos el mecanismo de solución de controversias inversionista-Estado como un mecanismo excepcional en donde el inversionista tiene única y exclusivamente los derechos que los Estados parte le han otorgado. Más allá de la sofisticación del arbitraje inversionista-Estado y de la habilitación para litigar en igualdad de condiciones, los derechos del inversionista en este tipo de procedimientos son consecuencia del consentimiento otorgado por los Estados. En tercer lugar, entendemos que la jurisdicción de los tribunales está sujeta a una condición implícita de legalidad. Por esta razón, el Estado colombiano...
I'm sorry, Ms. Ordóñez, could you slow down a little bit because I see that the translator is not really following.
Okay.
Thank you.
En tercer lugar, entendemos que la jurisdicción de los tribunales está sujeta a una condición implícita de legalidad. Por esta razón, el Estado colombiano tiene la carga y el tribunal arbitral la obligación de verificar con toda diligencia y hasta el máximo de sus posibilidades que la inversión no contraría principios fundamentales del ordenamiento jurídico del Estado receptor. Genuinamente consideramos que esta obligación es reforzada cuando la alegación de ilegalidad es tan grave que involucra el orden público transnacional. Finalmente, quisiera concluir haciendo claridad sobre algunos aspectos básicos de la acción de extinción de dominio que deberían estar claros para todos después de casi 4 años de estudio, como ya lo dije, pero que parecen no estarlo para nuestros colegas de la parte demandante. Esa aparente incomprensión, que ya hemos calificado más bien como una tergiversación conveniente, explica una parte importante de sus reclamos, los cuales son improcedentes. Primero, el procedimiento de extinción de dominio comprende 2 etapas, una de ellas completamente reservada, incluyendo para los posibles afectados. Por esta razón, después de casi 4 años, deberíamos tener claro que no son procedentes reclamos de publicidad en relación con las actividades que se surtan en esta etapa, incluyendo la decisión de imponer medidas cautelares, y por eso no resulta acertado señalar que la imposición de medidas cautelares debería haber estado precedida por reuniones de consultas con el afectado para conocer si se trataba de un tercero de buena fe exenta de culpa. Por la misma razón, resulta absurdo señalar que la respuesta a un derecho de petición de información pudiera ser un mecanismo siquiera medianamente diligente para saber si un determinado terreno o grupo de personas estaban sujetos a procesos de extinción de dominio. Aun si lo estuvieran, si la actuación estaba en fase inicial, la respuesta al derecho de petición jamás hubiera podido dar cuenta de dicha actuación. Segundo, el proceso de extinción de dominio es un procedimiento progresivo dirigido a establecer la procedencia de la causal de extinción de dominio y la existencia de terceros de buena fe exenta de culpa, siendo esta última la única instancia aceptada por el derecho colombiano para que se generen derechos de propiedad sobre bienes de procedencia o destinación ilícita. Ese carácter progresivo implica que el establecimiento de las anteriores situaciones tiene un primer momento en la fase inicial a cargo de la Fiscalía, pero transita a una fase de juicio ante los jueces de extinción de dominio. Aunque a la Fiscalía le corresponde tomar medidas como la imposición de medidas cautelares o la presentación de la demanda de extinción de dominio, deberá defender su caso ante un juez de extinción de dominio. Esta defensa incluye la existencia de la causal y la inexistencia de terceros de buena fe exenta de culpa, si este es el caso. Esta descripción simple y que todos deberíamos conocer descarta por completo cualquier alegato que sugiera que, si una determinada información no era conocida y no fue invocada durante la fase inicial, ya no pueda ser motivo de análisis y debate en la etapa de juicio. El mismo procedimiento de extinción de dominio permite la posibilidad de invocar pruebas sobrevinientes y trasladar evidencias de otros procesos cuando sean necesarios en el marco de extinción de dominio. Con estas aclaraciones, doy paso a Yasbani Fatemi, quien continuará con las alegaciones del Estado.
Thank you very much.
Mr. President, members of the tribunal, thank you very much. Following from Ms. Ordóñez's comments, I will now address a number of points you will see on slide 2, which is my table of contents. We will address the essential security exception, issues of jurisdiction, and the prematurity and abusive nature of this proceeding. I will address all 3 first points. Following that, Ms. Herrera will address issues of liability and the fact that the respondent has not breached its international obligations under the TPA. And finally, Ms. Rybko-Borman will address the issue of damages and the fact that the claims are not entitled to damages in this case. Before I start, Mr. President and members of the tribunal, I would like to make a few opening comments for which I do not have slides, but which I would like to address based on what I heard this morning. And these are important points. The first point I would like to make is, as you know, it's always important for tribunal members to go back to the record and to double check the record and to not make a decision or deliberate based on misrepresentations by parties and out-of-context quotes. We saw a lot of out-of-context quotes this morning in the presentation by the claimants. I would urge the tribunal to go back to the record and truly to double-check everything in the context in which questions were posed and answered, and the actual arguments that were made. It is in that context also that I made the previous comment that had we had the same notion as our friends on the other side, that we could put a lot of slides and not argue them. The point that I was making is that in some arbitrations I've been where simply slides not argued have been excluded from the record because these are submissions that are not put before the tribunal. So we're not asking for that. I just ask for the tribunal to be indulgent in the way that it will indeed look at the parties' submissions. And we have been selective because we were trying to accommodate the tribunal's directions of arguing in 3 hours. And by definition, we will not have time to address everything, so we will refer the tribunal back to our submissions with respect, and we will do our best to address the rest today. The second point I would like to make is, again, going to your experience as arbitrators. You have sat in many arbitrations, and you know that by definition there's always ships in the nights. You have one story narrative and you have another story narrative, and the two almost never reach each other. In this case, it feels like this is also the same. You hear one narrative on the other side, which is a investor mistreated by Colombia, a good faith investor having done everything he can to invest in Colombia, has been mistreated at every point in time, at every turn. And Colombia has been this horrible state and taking action against him, being retaliating against every single action and moral damages and so on and so forth, with a lot of theatrics. You will have heard that. We will not engage in theatrics because that's not what this is about, but we will address the gravity of the situation. This is a very serious case. We heard a lot of personal comments by Mr. Mulu and his colleague about going to Colombia and taking pictures and having seen how Charlie is wonderful. The only comment I will make is that in my over 25 years of practice, I have never been in a situation representing claimants and investors or representing states. I have never been in a situation with this level of gravity. And I'm not saying this lightly. We are in a case, and this is what you really have to realize, and I will address it in the few moments to come. We are in a case where Colombia is trying to put some order in its country in relation to narco-trafficking, which is a very extremely serious situation, not only for Colombia, but for the world. Because these are violent, organized groups, and they have and as you will have seen from, and you will see from also the US's perspective, they have, they go much beyond Colombia in what they do and their actions. So this is what you have in front of you. This is Colombia taking action through asset forfeiture proceedings, and you will have heard a lot of misrepresentation about what these are. An asset forfeiture proceeding is, by definition, as its name says, relating to an asset. The asset is meritage lot. It's not about Mr. Seda as such, so it's not that Colombia has discriminated Mr. Seda or looked at Mr. Seda, it has looked at meritage. And if Mr. Seda is taken and captured in those measures, it's his own doing. It was his own obligation to go through due diligence when he allegedly invested in Colombia and to ensure that he was investing in a framework that he knows, because this is Medellin we're talking about. So he had a duty of due diligence. And anything that may have happened, including asset forfeiture procedures, it's his own doing. Now, we heard from Mr. Mulu that they have not shifted, we have shifted constantly. No, they have frozen their case at one particular point in time, which is when the measure of asset forfeiture proceeding was taken at beginning. We're not shifting position. By nature, asset forfeiture proceeding, as Ms. Ordóñez just explained, is that it's evolutive. It's an ongoing proceeding. It starts and it continues. There's proceedings before the courts. That's why we say it's premature. You still have a process that will continue going on. So this is by nature evolutive. So by definition, the facts will evolve. The other reason, and so we're not shifting at all. So this is the nature of asset forfeiture proceeding. The other point I want to make is that there's a tension for Mr. Moulou to say that, oh, their case is shifting all the time, but when it comes to essential security, they say, oh, it's all a recast of what they said at the beginning. It's either a recast, and we've said all along, and it's the same thing, and we're recasting, or it's not the same thing. So you cannot have it both ways. The reality is that the case has evolved, one, because assets for future proceedings evolve, and two, because in relation to legality questions, we, Colombia, and you will have heard Ms. Ordóñez this morning about the prosecution of Colombia having gone through the very taxing, burdensome exercise of looking at the investigations in relation to the Méritage and responding, and this is the claimant's own doing. They asked for this. They asked for document production. It all started because Colombia went through that process to produce, following the tribunal's orders, investigation proceedings, and that is when all of these illegalities started to come out, and that's when Colombia started to connect the dots between what it was seeing in the asset forfeiture proceedings in relation to the Méritage, and it was seeing in this arbitration in relation to Mr. Seda, Mr. Benegas, who has come out because of these evolving situations. Likewise, the fact the rebuttal evidence that was not admitted, this was rebuttal evidence to Ms. Giraldo's statement that was belatedly put by the respondent. I'm not going to rehash our letters. So if there's any evolution, it's one, because of the nature of asset forfeiture proceedings, and simply because everything that has been uncovered, it's because we were responding to requests in document production by the claimants or rebutting to statements made by Ms. Giraldo. I will come back to that. So that, again, is extremely serious, and you have to take that into account. Our case is not shifting. Our case is addressing very precisely what this tribunal is confronted with. And finally, maybe one point on Mr. Moulou's comment at the end about moral damages. And I will finish here with where I started. This is not a case of an investor being treated poorly, a good faith investor. This is a case about Colombia being dragged unfairly, abusively, into an arbitration through an instrumentalization of arbitration when Colombia is trying to address wrongdoing by the Oficina de Envigado. This is what we're talking about. And now I'm going to address that more precisely. Starting with the essential security, because, and you've heard that. I will try to, of course, I'm not going to rehash what you heard in the opening, but I will address some of the important points that you have in front of you. I'm at slide 4 now with the first point, which is that given that Colombia is invoking that exception under Article 22(2)(b) of the TPA, any determination by you would seriously undermine Colombia's essential security interests. So these were the factual circumstances and the context for you to understand why essential security is such an important matter here for Colombia, dealing with the treaty itself. Before I do that, I would like to address 2 points that were made by Mr. Moulou about the timing issue. So he says that you should just look at the period of time when the measures were taken, and then you don't want to look at the rest of the period. And I think he refers to the Nicaragua case. Well, our response to that is that, and of course we made this point in the opening, but it's as if we had not said anything, so they rehash the same thing. But again, we need to respond to that. The treaties are not the same thing. The treaty here does not have the same elements as the one that was in the case of Russia traffic in transit, where the treaty addressed measures taken during a certain period of time. It's not the case here in the TPA. The second point is that the evidence at the beginning was based on the Oficina being the previous owner of the Méritage lot, and Mr. Benegas is also related to Oficina. But as you know, the arbitration revealed that the asset forfeiture proceedings are protective of something much more serious. So again, you have to take into account the evolution of the facts. The measures are taken into account that evolution. But importantly, Article 22(2)(b) doesn't bring any limitation as to the timing of the measures. And here, the measures complained of have a continuous nature, and you have to take into account the fact that they have, because the asset forfeiture proceedings are ongoing, and also because of this arbitration, simply. Because of this arbitration, we came to connect the dots between the here nor there. The Nicaragua case cannot be raised because simply the treaties are different, written differently, and the language has nothing to do with this case. On the MFN, I will say just one word. MFN clause cannot apply because you have the language of the TPA, which says nothing in this treaty and excludes pretty much everything. So it goes to the fundamental, and Ms. Ordiña talked about it, is the fundamental consent of Colombia to accept arbitration in certain circumstances. So it's not enough that we have, so what they say is that, oh, forget Article 22(2)b, just go get a treaty that doesn't have that exclusion. But that exclusion is fundamental to the US and to Colombia. And you can just not forget that, because that's the very substance of the consent of Colombia to this case. Now, if I may go to Article 22(2)b at my slide 10, you see that, the language is pretty clear, right? So you have the nature of the essential security itself, which is the Colombia's sovereign power to take measures against the worst type of organized crime that has historically been known in Colombia. That's just what I just mentioned. And the language shows that the invocation of the essential security exception renders the matter not justiciable. Not justiciable means what? It means that it cannot be reviewed by a court simply. So this is what you have in the text. It said nothing in this agreement. So this is essentially an entire exclusion. Nothing in this agreement shall be construed to preclude a party from applying measures. This means that a party can apply measures notwithstanding anything that is in the treaty, and therefore that can be done without any legal assessment. I will come back later to the footnote because our friends on the other side would like to forget about the footnote, but it's pretty much there. But non-justiciability, and I will come back to the parties' joint interpretation of the treaty in that regard. This is what it means. A party can take measures, can apply measures protecting its own essential security interests without notwithstanding anything in this treaty, including the investor-state dispute resolution. Now, if you look at my next slide, this is not new. We said it in our rejoinder, slide 11. We had said it in our rejoinder of 21 February 2022. So now they say, it's all new, and you, because the US said it, you said it. No, we said it from our rejoinder 21 February 2022. Not surprisingly, because this was actually discussed between Colombia and the US during the travaux préparatoires. And you see that the US on the 3 May hearing actually said, and I quote from the US, once a state party to the TPA raises the exception, its invocation is not justiciable, and the Chapter 10 tribunal must find that the exception applies to the dispute before it. And you, on the left side, you see that we had said that the dispute is not justiciable on the grounds of Article 22(2) of the U.S. Colombia TPA. So it's not new. We said it at the outset as soon as we invoked the exception. On my next slide, the claimant argued that this is belated and in an event it's meritless. And you see on the left side, we put an excerpt of the rebuttal. They said it's time barred. And they said during the hearing that we changed position. I just addressed that. And they say that under Article ICSID, Rule 41(2), the tribunal has discretion to consider jurisdiction or competence at any stage of the proceeding, but cannot do that for matters of justiciability. With respect, this is wrong for the 5 following reasons. First of all, ICSID's procedural rules cannot trump the mandatory language of the treaty. It's not only the mandatory language of the treaty, but I will come back to that. It's also the authentic interpretation of the treaty, which is binding on this tribunal. That's the first point. The second point is that Article 41(2) essentially, and the claimant's interpretation of that is incorrect because the tribunal has the power and duty to satisfy itself at any time that it has jurisdiction. What does that mean? That means that you have the power at any point in time to raise ex officio your jurisdiction because it's your duty to ensure that you cannot proceed without having jurisdiction. So because that can be done at any point in time, a fortiori, it also is something that you can and should do in terms of justiciability, which is even beyond jurisdiction because it means that you do not have the power to exercise jurisdiction. They say also that this is belated with respect. We have raised the exception based on newly discovered fact that reveal the seriousness of the circumstances of this case. I explained earlier, this is because of everything that was uncovered after the document production and the investigations that we had to submit following and complying with the tribunal's orders. And following that, the claimants had ample opportunity to address the point and to present their case in that regard, so they cannot complain about any due process issue. In the alternative, what we say is that if you look and seek to, so even if you're not with us on not justiciability, which we say you should be, because essentially, as soon as we say it applies, and Colombia is entitled to take measures without any assessment by a court, you still lack jurisdiction, and that's my point C, to decide the dispute. On my slide 14, we have put the chart of essentially how you should look at this from the point of view of international general law as codified under the Vienna Convention on the Law of Treaties. I will address each of them with more or less detail and rebutting. You don't have everything on slide because I had not planned on saying it, but again, having heard my colleagues, I have to respond to some of these points. First of all, of course, you have to look at ordinary meaning of Article 22.2b. I will come back to this, and I don't talk about it now. Context of the Article 22.2b, I had not planned on discuss it, but I will rebut briefly the context. We discussed this during the opening. You have to take into account that it's at the end of the treaty, and you know that it says nothing in this agreement. So the fact that it's at the end of the treaty shows that it encapsulates the entirety of the treaty, including investor-state arbitration and including compensation. There was a point made by Mr. Muller about the US actually having had a very strong desire to allow compensation for investors. With respect, this is wrong. You just need to go back to what the US actually said during the hearing of May. And if I may refer you to page 390 of the hearing of May, that's 3 May 2022. Lines 9 to 21, which I will read for the record. So page 390, line 9 to 21. I quote from the US government. I would like to address an argument we heard from claimants yesterday that Article 22.2b merely allows the state to apply or continue to apply measures that it considers necessary for the protection of its own essential security interests, but that Article 22.2b does not address the question of liability or compensation. The United States disagrees. Once the essential security interest exception is invoked, a tribunal may not, thereafter, find the relevant measure in breach of the Chapter 10 obligation and may not, consequently, order the payment of any compensation in connection with that measure. It's very clear what the US says, and here again, there's an agreement between the US and Colombia, which dates back to the travaux préparatoires, and I will come back to this. So if you look at the context, the fact that it's at the end and the language together mean that everything is excluded, including investor-state arbitration and compensation, as the US has clarified in its submission. Object and purpose of the TPA. You saw there was a slide, I don't have it with me, but there was this very interesting slide about the preamble of the treaty, which is essentially about allowing, promoting broad-based economic development in order to reduce poverty. My friends forget some other, and with permission, I don't have it in my slides, so I will respectfully refer you back to the actual here. Yes, so they have quoted from the whereas 2, 3, and 4 in their slide 4. So promote broad-based economic development in order to reduce poverty and generate opportunities for sustainable economic alternatives to drug crop production. So you see that drug is indeed very much in the state's mind when they entered into this treaty. But look also at what they do not address. So if you look at the preamble in your time, because I don't have it handy, 4 whereas before the end, I quote, promote transparency and prevent and combat corruption, including bribery in international trade and investment. And the last whereas, No, sorry, it's not where it's on the first page. So it's first page, fourth before last, and the last on the first page of the preamble. I quote, "preserve their ability to safeguard the public welfare." So these are important object and purpose of the treaty that they do not mention on the other side of the table. But of course, fighting against corruption, including bribery, international trade investment, that is also part of what the treaty, the states had in mind. On effet utile, going back to my chart, I will respectfully refer you back to our submissions that this has to be a purposeful provision. Otherwise, if you don't give effect to it, you simply are not giving effect to a very important provision in the treaty. And now I'll come to the rest, which is authentic interpretation and travaux, but saying one word about the ordinary meaning at slide 15. So you have, of course, on the left side, the actual text, nothing in disagreement, and that, of course, again, exclude ISDS and exclude compensation, shall be construed to preclude the party from applying measure that it considers necessary for the protection of its own essential security. What you see is that it says it considers necessary. Measures it considers necessary. This means that it's a subjective determination by the state who invokes the exception. It's not an objective criterion, it's a subjective one. This has been consistently interpreted, you have that, the references on the right side, by every court or tribunal that has had to deal with similar language on the self-judging nature of this sort of language, meaning it considers necessary. They have always interpreted this as a carve-out of jurisdiction. And if you look at the footnote, which is not discussed by the other side, you see that it says for greater certainty. So it's just for the avoidance of doubt. It doesn't mean that the text is not clear. The text is very clear, but to even clarify more, they say for greater certainty, if a party invokes the provision, the tribunal or panel hearing the matter shall find that the exception applies. And I'll come back to this. The US and Colombia took a position on this in the travaux préparatoires and otherwise. I want to say here one word about equo oro, because our friends have said a number of things in that relation. I just want to make sure that you go back to actually what equo oro says. The provision under equo oro, which was Article 22013 of the Canada-Colombia FTA, is a general exception related to environmental matters, not essential security. So it's not the same thing we're talking about. And that provision is fundamentally different from the provision you have in front of you because it does not have the self-judging elements that are expressly provided in this provision. So these are two main reasons why equo oro cannot apply. And you have to look at the chapeau of equo oro, which essentially talks about measures adopted by the state that are not applied in a manner that would constitute a means of arbitrary unjustifiable discrimination. That's what they refer to. That is not found in Article 22(2)b. So again, the provisions are completely different. And the equo oro also applies to provisions contained in Chapter 8, which is the investment chapter of that FTA, whereas Article 22(2)b applies to the entirety of the treaty because it says nothing in disagreement. And of course, as we discussed, that means that it includes investor-state arbitration and compensation. So for these reasons, equo oro simply is neither here nor there, and it cannot apply. And it's not binding of this tribunal, for one, but in any event, it is a completely different finding. Now, if you were not with us at all on that, and I'll come back to this, the exception has been fully invoked by Colombia in good faith, and I will show that. But before I do that, on my next slide 16, I want to discuss the interpretation by the parties. So you see here on the left side, Colombia's positions, on the right side, the US submission. On the left side, you have Colombia's rejoinder of 21 February, and you see that Colombia, and you see with the arrows and the boxes, red boxes, you see that we have referenced what was exactly the same wording used by both states. So in Colombia's rejoinder, we argued and submitted that this renders the case non-justiciable. The US, in the hearing of 3 May, said exactly the same thing. They said it's not justiciable. We argued also the self-judging nature of the provision, and you see on the right side that the US also has said the same thing. The fact that both states are saying the same thing about interpretation means that there is an authentic interpretation of the treaty by both contracting parties that binds this tribunal. You cannot escape the fact that both states are saying the same thing. And the US, who are present today, are listening to this. The US have probably, when they come and argue interpretation, they have at heart the correct interpretation of the treaty and ensuring that the tribunal understands what the US had in mind when it entered into this treaty, just as Colombia had the same thing in mind at that time. And you see that during our oral submission, which happened the day before the US, and for that matter, we had no clue what the US would say. So on the 2nd of May, we argued the subsequent agreement under the Vienna Convention on the Law of Treaties, the fact that the same things would be found in the submissions of the US and Colombia, that makes it under Article 31(3)(a) of the Vienna Convention on the Law of Treaties, a subsequent agreement between the parties that makes it an authentic interpretation. And you see that the next day, the US, relying on the same provision, said that this is the parties, the TPA parties' common understanding. So that, if anything, confirms that the two parties have the same interpretation. They review this as not justiciable, meaning that the states cannot assess. The tribunal, cannot assess any or determine the actions of Colombia as soon as Colombia invokes the exception, and that it is self-judging in the sense that it's a subjective determination by Colombia, and that this is a joint interpretation by the two states.
I'm sorry to interrupt you, Professor Bani Fatimi. I was just asking the chairman if I should ask my question tomorrow when we have time for the questions, and I've been told to ask it right away. Assume, for the sake of argument, assume the United States is invoking the treaty, and it's invoking it in bad faith. Does the arbitral tribunal, in front of which the United States would invoke the treaty, have to step back and say, this is it? Or does the arbitral tribunal have any power to assess whether or not the invocation is made in good faith? I am not saying by this, let me emphasize that in our case, there is any issue about that. I'm just asking for my understanding of the provision. So I'm taking the other example for ease of reference, assuming a Colombian investor in the United States, let's say it's the Trump administration, and it's invoked in a totally crazy manner. Does the arbitral tribunal, sitting under the treaty, have the power to adjudicate that?
I will start with the end, which is that, as you will have understood from our submission, we have a series of alternatives. One is it's not justiciable. Two, you do not have jurisdiction. In the event you decide that you stand against us, that you do have jurisdiction, we have invoked this in good faith, and I will address that later on. So just to give the tribunal comfort that even if you work to go there, which we say is wrong, because this is not the sense of the treaty, you should feel comfort in the fact that this is an extremely important and serious matter for which Colombia has raised the exception in good faith. Going to the first question, I am not authorized by the US to speak for the US. So I cannot say anything for the US. The US are hearing us. If they have anything to say, they probably will. All I can say is that based on the interpretation that you have seen from both states, from Colombia and from the US, and I'll come now to the travaux préparatoires, but from what you've heard at the hearing, self-judging means self-judging. When the US says it's not justiciable, meaning that it cannot be submitted to a determination by a court or a tribunal, that's what it means. So it's that, in other words, it's intrinsic to the concept of essential security. If a state says, the measures that I've taken go to my essential security, nobody other than that state can determine what that essential security is. And that's enough. So that's what self-judging means. And that's what the subjective determination means. And it's only for, and that's when I say it's a purposeful meaning. You have to give effect. It's a utility. You have to give effect to this. Otherwise, you just are overlooking an essential provision in the treaty. There's a reason why the two states put that text in the treaty. Colombia, by the way, if I recall correctly, there are 17 BITs and TPAs in which Colombia has this in its treaties. And again, there's a reason why, because Colombia is engaged in one of the worst efforts worldwide in relation to narco-trafficking and armed and bloody crime. These are some of the worst organizations worldwide. Now having relationship with the Hezbollah. I mean, we're talking about extremely serious wrongdoing around the world. So if Colombia says, this is my essential security, that should be enough. Now, if you would like to look at jurisdiction, you have to say, okay, I look at jurisdiction, I look at, it's not justiciability, but it's the jurisdictional still. You need to look at that and determine that Colombia is right when it says that nothing in this agreement shall be construed. It's still self-judging, and you should say, I do not have jurisdiction, because Colombia is saying that it's essential security. So you can either say, I do not have the power to decide and assess, or you say, I do not have jurisdiction. As far as I'm concerned, there's a level. Its power comes before jurisdiction, but the end result would be the same. I, as a tribunal, cannot make a determination based on law in relation to this point.
And the measure under Article 22 is the overall fight against a particularly dangerous form of organized crime that is active in the drug trade.
Yes. And the meritage was targeted. Ms. Herrera will come back to this, because there was a huge number of misrepresentations about asset for future proceedings, and she will explain what exactly this is. It follows the assets. So Colombia looks at the meritage in the first instance. Meritage, at the time, we saw that there was in the tracing of the asset, there was...
I've got that.
Okay, but then, as the facts uncover and as the facts keep growing, and that's when we invoked essential security, we saw more and more. Okay,
I got your point. But what you're saying is that measure is not, contrary to what we heard this morning, something specifically adopted. For instance, it would be a determination of some kind in an international environment where Colombia would have said, well, we regard the fight against organized crime as an essential interest of our state due to the past experiences we've had, et cetera, et cetera. It's not that. It's the simple existence of this undoubtedly extremely important and extremely difficult crime against fight against this form of organized crime in which so many people have lost their lives.
Yes,
it's just the fact that it exists is what you're saying.
The continuum.
That's the measure.
The continuum of all of the measures that, and indeed the existence of the asset for future proceedings in relation to the meritage, because this is the subject of the case that's before you. What the case before you is not the entirety of the fight against narco-trafficking. What's before you is Colombia's fight against narco-trafficking. I will address that very briefly. But the measures taken in relation to the meritage, all of the measures, the continuum of those measures and how they're unfolding, because as we go more and more, the assets for future proceedings are developing and more facts are being uncovered, all of those measures in relation to the meritage, given the fight against narco-trafficking and money laundering.
Thank you, and sorry for the interruption.
Not at all, Mr. Arbitrator, thank you. So nothing new, both parties, both contracting parties to the treaty have maintained consistently the same view of how this should be interpreted. And it's a very specific determination and as you see, consistent. Now, if I may come to...
Excuse me, Ms. Banifatemi, the interpreters are asking if you could please slow down a little bit.
And she keeps being interrupted, I'm sorry.
Sorry.
I'll try to slow down, for sure. Apologies. So I'm coming to the further alternative, which is that in any event, this has been raised by Colombia in good faith. And the measures complained of are designed to protect Colombia's essential security interest, and therefore, there's no universe in which the tribunal could find that Colombia has breached its obligations under the TPA. On my slide 19, you see that there's, so you have again the provision itself, and there's 3 requirements that we have highlighted. The first, that there has to be measures that were adopted. That's not contested by the other side. That those measures are considered to be necessary for the state who invokes that exception, and that's not contested. The only requirement that's challenged by the claimants, as you see on my slide, is the protection of the own security interests. And the criterion, which is not contested, is that the measures must plausibly be expected to protect the state's essential security interest. Now, on my next slide, I will try to, in my next slides, plural, I will try to explain what we are now really confronted with. The consequences of that invocation is that the tribunal cannot find liability and award compensation. There's also 3 reasons for that. So first of all, as you know, the essential security exception is a derogation to the entirety of the TPA. I've explained that, so no breaches and no compensation. Importantly, this is my second bullet, in order to award compensation to the claimant, the tribunal would be taking a premature measure because the asset forfeiture proceedings are still ongoing. They're evolving. The meritage lot has not yet been forfeited. And there has been no determination by the Colombian court as to whether or not Newport is a bona fide without fault third party. So this is ongoing, so therefore it's completely premature for this tribunal to decide that there has been any breach of the treaty because the Colombian courts had not made any determination in that regard. And finally, any determination by the tribunal of Colombia's actions in the circumstances poses the risk of interfering with Colombia's essential security interest and would be essentially allowing the instrumentalization of international arbitration by Mr. Seda and his acolytes to the benefit of criminal organization and would be contrary to international public policy. And we said that the tribunal should be extremely cautious before doing that. I will say a few words about jurisdiction, if I may, and I'm in your hands as to when you wish to have a break. The first point is that the claimants have not made a protected investment under TPA and the ICSID Convention. The claimants have first, so on slide 37, you see that the claimants have failed to show that they provided any significant contribution or of capital or other resources into the project. As you now know, pursuant to the financial statements of Newport, less than $2 million were paid by the shareholders, including Newport. This is anything but substantial. Interestingly, it's through the unit buyers that the Meritage project has been financed mostly. And as Vesti versus Venezuela said, any capital resources committed by the claimants are incapable because of their insignificance of contributing any meaningful way to the objective of the, in that case, or in this case, the US-Colombia TPA. Because there's no significant contribution and not real contribution, in fact, there cannot be any risk. And Mr. Seda cannot complain of being mistreated or legitimate expectation. And one word here about that and the risk. If anything, when he allegedly invested in the Medellin region and dealing with cartel individuals, he should have had the expectation that the asset forfeiture proceedings might be initiated against the asset that was the subject of his alleged investment. And that, in that sense, there cannot be any legitimate expectation. There's only a real risk in that sense. But in any event, we say that as the definition, he didn't really take a risk as such because the contribution was nowhere. However, we said that there's an expectation of gain and profit, which is not sufficient to establish a protected investment was made. And on profit, I just want for you to remember the very interesting proportionality. When they talk about proportionality, but look at, they invested even less than 2 million. It's actually the unit buyers who invested. But against that 2 million, they're asking for 255 million. This is better than the casino. They win at every step. So if you please look at the cross-examination of Mr. Seda during the hearing of 3 May, for example, page 444, lines 15 to 22, I asked him that he had identified land in previously dangerous region and the perception of danger causes prices to be fixed at the bargain. And he said yes. And likewise, at page 447, I asked him again, this is what I call being a good businessman. You buy a piece of land in regions that are either perceived as previously dangerous or still dangerous, and you expect to make a very high profit out of it, right? And you talk about profit of 1,000%. And he accepts, he agrees. And he says later on at page 448 on lines 17 and 18, my job is to give returns to my investor. That's the way I can do what I love. So what is interesting for Mr. Seda is that he barely makes any investment and he expects a 1,000% profit and even more, $255 million in this case. Again, it's better than the casino. On my next slide, I will be very fast because B, you have under Rule 41.2 of ICSID rules, again, this is a question of jurisdiction. So at any point in time, you have to raise matters of jurisdiction, and that includes the legality of the investment that was made, which goes to jurisdiction. And you have an example here in Infinito versus Costa Rica. Quote, the tribunal has a duty to assess ex officio in accordance with ICSID Rule 41.2. As a result, the tribunal cannot merely rely on the parties' assessment and must engage in its own inquiry on the basis of the evidence on the record. This is particularly true when there are allegations of corruption, which is a matter of international public policy. So you do have the duty when you're confronted with illegality of the scale that we're talking about. Even if we had not raised the illegality of investment, it would be your duty to raise that and to address that. And you have case law in that regard on my next slide. It's Phoenix, Oxus, Mamid Oil, and you look at Phoenix, for example. Illegal investments, according to national law and the host state, cannot be protected through an ICSID arbitral process. You're familiar with the case law. And going to doctrine, of course, I wanted to pay tribute to Professor Gaillard, late Professor Gaillard's writings on corruption matter, and that the investment has to be made in conditions of legality. But don't take only Professor Gaillard's word for it, take Mr. Moulou's word for it. This is an article written in 2010 at slide 43, where he says that, I quote, the concept of a host state to resolve disputes with investors is governed by certain overarching principles, including transnational public policy. And further down, he says that applicable law includes transnational public policy against fraud and corruption. And again, he says, I quote, breaches of transnational public policy may also prevent the admissibility of any claim that relates to an investment that involved fraud and corruption by the investor. So in 2010, when he's not representing Mr. Seda, he agrees with me. Next slide, 44. Just to wrap up, that the 2/3 of the claimant's claim concern projects unrelated to the Meritage project. Actually, Mr. Moulou showed this to you. It's only 31% of the claims of 64 million that relates to the Meritage that is part of the quantum that they're asking. If I may, I can finish, and before we have a...
The court reporters are asking for a break.
Okay, I'll stop.
Okay, please stop.
Thank you.
Thank you for your endurance, both court reporters. That was quite something. Let's see, it's time 4:25. Let's say 4:40.